261st District Court is back in session.
Okay, let's proceed with the testimony of Mr. Saylor. Ms. Burgess, you may proceed.
Thank you, Judge. Mr. Saylor, do you recall before the break testifying that you could not work for both Flow Sports and Rockfin under your contract, correct?
I asked, you mean in those text messages?
Well, it was in the email exchange where Mr. Floriani told you that if he recalled your contract correctly, you couldn't work for both, right?
I don't know if I was talking about me specifically. I think I was talking about a hypothetical on what Rockfin's exclusivity policy was.
Let's go back to Exhibit 2, Mr. Weisrott, and go to that exclusivity section at the bottom of the second page.
Mr. Saylor, does this refresh your recollection that he told you couldn't go because of the way your contract was worded, right?
Yes, but this is a hypothetical. I lead with Greg Warren. You know, what I was asking in this question is, if somebody is a creator on Rockfin, do they have to be exclusively on Rockfin? That's what I was asking.
Well, the way that he answered, though, was about your current contract with Flow Sports, correct?
Yeah. Yes, that's right.
Okay. And he said that contract would prevent you, as he recalled, from being able to do both, right?
Yes.
Okay, and then let's go to 160, Mr. Weisrott. To the third page at section A. I'll give you a second to look at that.
What was the question?
Oh, I just said, I'll give you a second to look at this. This is your PIIA.
Okay, I've read it.
Okay, and so during the survey, the time that you were working there, your contract said that you wouldn't work with an entity that competes with the company in the business of the company, correct?
Yes.
And the business of the company is defined as products and services in the sports video industry, correct?
Yes.
And that's what you acknowledged and agreed was the business of Flow Sports.
Yes.
Okay, and then if we go down to the next paragraph, Mr. Weisrott. That's the same language, the business of the company and competitor are the language used in small or Romanet 2 and 3, but not in the first section, right?
I'm sorry, what was the question?
Sure. The
Document,
provision that
excuse me, the document says what it says. What's your question about it? I mean, we can all read it. We see what's in 1 and 2 and 3, but what's the question for him?
is that so, Mr. Saylor, the prohibition on competing while you worked at Flow Sports was the same as the prohibitions in parts 2 and 3 of the year after, correct?
Oh. Yes.
And meaning that it's tied to a definition of business of the company, right?
Yes.
But part 1 is not tied to a definition of business of the company.
Part 1 is not the company in the region or cities.
I'm going to object that the document speaks for itself, Judge. You've already.
I'm not sure what the question is. I'm sorry. Maybe I misheard you.
Excuse me, I don't think he understands your question, but the document speaks for itself. If you want to ask him his understanding of it, you can certainly do that because the document's in evidence, but he doesn't seem to understand your question. So try again if you would.
Sure. Part B1, Mr. Saylor, doesn't use the defined term in capitals business of the company.
I would make the same objection, Your Honor. This is a construction. not asking for his interpretation.
Says what it says, and we're all looking at it. So we know what's in it and what's not in it. But what is the question you want to, what's the sort of bottom line question you want to ask him, I think is what I'm trying to get you to do. It says what it says. What's your question about that?
Mr. Saylor, both you and Mr. Floriani agreed that you could not work for both Flow Sports and Rockfin at the same time because of Section A, which is tied to business of the company, right?
Well,
Objection mischaracterizes his prior testimony and calls for speculation about Martin Floriani's intent.
So the question with regard to Mr. Floriani is what confused me as to what, who knew when, what, where. So maybe you could make it less compound and ask him questions that he can answer about his own thinking and his own statements and understanding.
In your email with Mr. Floriani, he tells you that you can't compete while you're working for Flow Sport. You can't work for Rockfin while you're working for Flow Sports.
You've asked him that question already, Ms. Burgess.
Right.
So, and we've read that email where he says, I don't think.
Right.
Not that he knows, but that he doesn't think so. We've read it, we've seen it. What is the sort of the heart of the question for Mr. Saylor about this provision?
Unlike sections 2 and 3 here in B, Section A, I'm sorry, unlike Section 1 here in Section B, Section A is tied to the definition of business of the company. And Mr. Weisrott, can you go back to that?
That's not a question, that's a statement. What's the question you want to ask Mr. Saylor?
So in order to be prohibited from working for Rockfin while you're working for Flow Sports, you have to be, Rockfin would have to be engaged in the business of the company.
I think she's asking you if that's your.
I'm sorry. I apologize. During the asking of the question, I was reading Section A. I didn't fully understand. I didn't fully hear.
No problem. I'll ask you again.
I'm sorry.
The reason you couldn't go to Rockfin is because Rockfin was engaged in the business of the company, right?
Rockfin was engaged in the business of the company?
Right. Rockfin was a competitor, which is why you couldn't work there at the same time.
No, first of all, in that email, I was asking a question about exclusivity. I was asking if Joe Schmo, a content creator off the street, became a content creator at Rockfin, if that person needed to be exclusive. Could he be on HBO and also Rockfin? Can he do a stand-up comedy show in the Laugh Factory and also be on Rockfin? Martin responded with some sentence about me personally. When you're talking about this, I don't consider Rockfin a competitor or Matt Scouts a competitor with Flow Sports.
We know that under your contract, you couldn't be on both, right?
I know Martin said under your contract, I don't think.
Now, when Mr. Floriani reached out to you in February of 2019, he told you that it was past his time where he had a prohibition on solicitation, correct?
There was a conversation I had, I don't know when, that I said something to Martin, like something about it's cool to talk now or something. And he was like, yeah, that's well past. That his 1 year or whatever. I don't know what his terms were, but it had passed.
And did you know that that too was limited to competitors?
Competitors?
That you couldn't solicit people from Flow Sports to go work for a competitor.
Objection vague.
Yeah.
I'm sorry, it's not clear to me if you're asking about Mr. Floriani's deal before or Mr. Saylor's, the question, I don't know what you're asking about.
Well, let's look at your non-solicitation agreement. Let's look at C on the same page.
Yes.
Okay, and you agree that when if, when you left, that you would not encourage any employee or consultant to terminate their employer on behalf of a third party, correct?
Anyway,
I'll withdraw the question. Let's go instead.
I don't know.
if it's okay. Or, but you can answer it if you want.
I'm not sure what you're asking.
Okay, let's go to 163. And page 10, my pages are a little off, Katie, so if you can help me. I want to go to October 23rd. Okay, so this would be, Mr. Weisbrot, I don't know if you can see the numbers in the bottom right as well, the base labels, but this would be 249.
So this is one of the documents we had questions about before, so council need to be alerted as to what page of this document that had been previously marked confidential might or might not be something we could show on the screen. So
Yes,
you
Your Honor.
can give them a heads up on what page you're asking them about. Is it, did you say base number 249? Is that what you said?
Yes, and I'll give you the Bates range because we are looking at it from a date range. 27th. So that was 249 and 250, just those two.
Anybody have any objection to displaying those two of this exhibit that's already been admitted? Okay,
No
all
objection.
No objection, Your Honor.
right, go ahead.
Okay, so you, on the 23rd of October, Mr. Floriani reaches out to you because he's heard in the wrestling community that you're not going to go to UNC. Is that accurate?
Objection, speculation.
Sustained.
Who is Tony?
I assume if we're talking about in relationship to UNC, it would be Tony Ramos, their assistant coach.
And he says he wants you to call him to put out an interesting idea, and that was at 3:12 in the afternoon. Did you have a conversation with him that afternoon?
I don't know if I had a conversation with him that afternoon.
And that evening at 8:51, you say, let's do it big, right?
Yeah.
What is the NHSCA contract you will get for Rockfin?
The NHSCA is a big tournament, big wrestling tournament. It's a
And
national.
it's exclusive to Flow Sports, correct?
Yes, that's right.
And then you say they'll sue us. That means Flow Sports, right?
Hmm.
And you say, but that's fine, right?
Yeah.
Now, when you ask if you're good with that, was that the start of your conversations with Rockfin about indemnifying you for attorney's fees?
No, and you misspoke in your opening that I'm not indemnified.
They're paying your fees, is what I'm saying.
Not wholly.
Okay. Do you recall testifying in your deposition that Rockfin was paying your fees?
I said specifically in my deposition, I said that hasn't been determined. And you said you haven't talked about that. And I said it's to be determined.
Okay, well, what got determined?
And Your Honor, if counsel could provide a page and line, if she's.
Question is whether or not it's now been determined.
Oh, okay.
What
Mr.
is?
Smith, that's our question to you. Have you now determined what, if any, portion of your attorney's fees Rockfin might be paying?
That's not determined, but I will be paying some.
Have you paid any to date?
No.
And I'm assuming your attorneys are not on a contingency fee or anything like that. They're getting paid.
You cut out a little bit, Mrs. Burgess. I'm sorry.
Sure, I'm assuming that the lawyers are getting paid
Yes.
by Rockman.
I mean, you want to be frank, I had a conversation with Carlos.
Oh, don't tell me
Objection.
client communications. Are the attorneys being paid
Sorry,
by
don't
Rockman?
tell us about that. You can just tell us if you know whether or not Rockfin is paying your lawyers.
Rockfin has paid some. I intend on paying some, frankly, this week.
And I'm thankful for that.
To get paid, for sure. But Mr. Floriani too agreed in that text that you are likely to get sued, right?
Sorry, it looks like Mr. Saylor's microphone has been muted. There you go.
I think that's a reach. I think that's, speculation. We good on that. I don't know. I think you're making an assumption that by we good on that means, hey, you're going to pay my lawyer fees, right? Because that's not what I meant.
But that happened.
What happened?
They paid your lawyer fees.
Your Honor, I object. This is repetitive and not really relevant.
He's indicated that it hasn't completely been determined who's paying what. He intends to pay some, they've paid some. I think we can move past.
Now,
What I meant by they
All right, Mr. Saylor, she's going to ask you another question.
okay, so then on the next page, the very next day, or actually a few days later, so no, it's the next day after that that exchange, Mr. Floriani sent you a written offer of employment, correct?
Mr. Floriani sent me a letter of formal offer. When was that?
He texts you about it on the 26th of October 2019. I mean, the 27th, I'm sorry.
It looks like that.
Okay, and then it skips to the 1st of November, and Mr. Floriani has actually, at that point, gone to Pennsylvania to meet with you to talk about this offer, correct?
Yeah. I mean, he came to Pennsylvania, yes. And, I'm sort of deliberating, I think, at this point. I think I have a habit of not communicating with people. And
Well, okay, and so he comes on the 1st, and then on the 2nd, he sends you your paperwork. Is that accurate?
don't recall what date. I can't speak specifically to what date he sent me paperwork.
Okay, but that's the day you quit, was after you got that paperwork, wasn't it? It's a Saturday?
I don't recall. I mean, I can't sit here and testify truthfully that I remember what day he sent me paperwork.
Let's go to, but this text, you would believe his text that he sent you paperwork on the 2nd.
Yes.
And that's early in the morning on a Saturday, or not early, but 9:45 on a Saturday.
9:45 on Saturday. Yes, I guess.
Okay, let's go to F560. Oh, wait, don't go. This is actually, stop. This is what Mr. Weisrott knows. They've marked the offer letter AEO, so don't show it. And I can just ask a few questions around it. By the way, Mr. Saylor's entire deposition none of it was designated as AEO or confidential, so I'm not going to go beyond anything that was revealed in that. So I would ask for you, just Mr. Saylor, can you see Exhibit 560, F560 without it going on the screen?
Exhibit 560. I don't believe. I mean, I don't have it in front of me. 560.
I'm gonna
offer it into evidence, and I don't think anyone objects to that evidence, but.
No
I just-
objection.
I don't know what the easiest. Okay. Judge, we can't hear you.
Ms. Klingseisen, is there any objection from your client to plaintiff's exhibit number 560?
No objection, Your Honor, and I emailed it to you, Willie.
Okay.
And
Does anyone have any objection to it being displayed?
Yes.
Okay. All right.
along the same lines, while we're doing
Oh,
that, there are attached.
Hang on a minute. We won't display it. It'll be admitted. We can talk later about whether or not some portions of that need to be redacted or sealed or whatever. But for now, please don't show it on the screen. Mr. Saylor, it's apparently been emailed to you and it's been described as an offer letter to you from Rofkin. So I just want to make sure you know what she's talking about. And let me know if you need to wait a minute to get a copy of it through your email to review.
And Judge, there are two attachments to it. They're separate documents. So if we could also get those admitted, that's F-166 and F-887. 877, sorry, one of those numbers.
877 and one what?
66.
Any objection to 166 or 877?
I have no objection, Your Honor.
No objection.
It looks like 877 may be AEO of Rockfin.
Yeah, both
Right.
attachments are AEO.
Excuse me, 166 is not marked AEO on my exhibit list, but it might be otherwise. I don't know. It's not marked that way on my exhibit list. Flow Sports Exhibit 166 is admitted, but don't display it yet until we can figure out whether there's any objection to that. Flow Sports Exhibit 877. Also not marked confidential on my list, but maybe is, so don't display it until we can clarify that. Neither of those is marked AEO on my exhibit list. Both are admitted, 877 and 166 plaintiff's exhibits. All right, go ahead, Ms. Burgess.
So are you able, Mr. Taylor, are you able to see number 560?
It hasn't come through yet, Ms. Burgess.
Okay, I can just ask you if you recall first. Do you recall getting an email from Mr. Floriani on Sunday, October 27th with an offer letter?
Sunday, October 27th. I thought you just said he sent it on Saturday. I don't know if that's
Oh,
material, but
Right. On the, actually, if you'll recall, the text had one on the 27th saying, I just sent you an offer letter, and the other was paperwork on the 2nd. It looks like we're gonna have to wait for a second.
yeah, I mean, as I said, I don't remember the exact date. It could have been Saturday, Sunday. I don't recall the exact date.
Okay, but on a Sunday, basically, I'm just gonna give you the day so that you can span across. Sunday, he sends you the offer letter, and then on Friday, he makes a trip to Pennsylvania to visit you.
Which came first?
The offer letter came first.
Well, she's not testifying, so if you remember, you can tell us. If you don't, tell us that.
I do not know the chronology of it. I know that once Martin came and visited me, he had a trip in New York. He stopped in here for a couple hours, went to New York. A couple days later, I got in an argument with Piles. I quit. Martin sent an offer letter.
Okay, and that's not the chronology quite as the documents show, so it would be helpful for him to
Yeah.
have the documents.
Again, Ms. Burgess, you don't get to testify, but you do get to ask a question. So please stop with the sidebar comments and just ask him a question. Hang on, she's going to ask you a question. That doesn't include testimony from her. Ms.
My
Burgess,
question, is, did you receive the document?
I just got the document that Ms. Klingseisen sent me. I got it, Kelly.
So, okay, so so what is Exhibit 560?
Exhibit 560? What Ms. Klingseisen sent me says Rockfin 477.
So, Mr. Saylor, some of the documents have different exhibit numbers on them than trial exhibit numbers because they were used for other purposes and other hearings and so forth. With regard to the document you received from Ms. Klingseisen just a few minutes ago, could you just tell us what it's entitled and the date of it?
It's an email from, yes, Your Honor. It's an email from Martin Floriani dated Sunday, October 27th. Subject, Rockfin offer. Willie, I'm proud to put this in writing.
I'll read it to me. Just Rockfin offers what's in the subject. Okay.
Yeah, I just making sure.
I believe, but I'll ask counsel for everybody to confirm that that is the same document that is in evidence now as petitioner's exhibit or plaintiff's exhibit number 560, correct?
Correct.
Yes, and
Yes, Your
477 is the Bates label. That's why you're seeing that number.
So everybody has the same document. We're all on the same page. That's the document she's asking you about. What's your question, Ms. Burgess?
Yes, what day was this offer letter sent to you?
It says October 27th, Sunday, 10 a.m.
Okay, and does that refresh your recollection that that's when the offer letter was sent?
I don't know.
That's right.
It looks like it did have an attachment.
Okay, if you look, can you see F166? Do you have that?
I don't have F16.
It's also Flow Sports 46 is the Bates label if you're getting them with those numbers.
Is it the offer letter itself?
Yes.
I don't have that document.
Okay, and hopefully, Ms. Klingseisen, if you could send him the documents. We did send a list. I know it's a lot of documents, but we did send a list of documents. It'd be helpful if the witness could have access to it if we're not going to be able to put these up on the screen. So, Mr. Saylor, you got a $10,000 signing bonus at Rockfin, correct?
Yes.
And you were told that you would get 92% of all the cash your customers bring in.
I believe that was, I'm sorry, did I miss something there?
Right. You were told that you would receive 92% of all the cash your customers bring in as a minimum guarantee for the first 18 months, correct?
I believe that was the agreement at the time.
Okay. And that changed later to just be the standard 72-28, right?
I'm going to be honest with you. I don't even know.
Okay. When we're talking about cash your customers bring in, that is subscriber dollars that go to Rockfin, right?
Cash the customers bring in, subscriber. Yeah, I guess. Yeah, I guess.
Okay, because the only way that your customers bring in cash is by paying $9.99 a month to Rockfin.
Yes.
True?
Yes.
And you also, as an employee, received a monthly fee to recruit content producers to Rockfin, correct?
That was an agreement that lasted maybe a month and a half, and I never really had those duties.
Well, that was the job you were offered, right? To recruit content producers to Rockfin?
No.
Can
No.
you see the document?
Yeah, I can see the document. I know what the document says. But what I have told you in my deposition and previous testimony is that I expressed to Martin that I was worried about having zero health insurance. So he wanted to find a way to get me health insurance to relieve my anxiety about that. And that was that. That was that job title.
But it was the title you were given and the job you were given.
Was the title I was given. I had no duties.
The,
I was responsible for nothing.
you're responsible for nothing, but you did get the health care.
Yes.
Okay, and if your duties were to recruit content producers to Rockfin, that would have been something, content producer at Flow Sports was what you were before, right? You were in the content department?
Yes, ma'am.
Okay, and in fact, the whole 8 years that you worked at Flow Sports, you were never in the production department, right?
No.
And in fact, content is the biggest department at Flow Sports, true?
If you say so. I don't know
Okay,
what.
and so,
She's not going to say because, as I've indicated, she's not testifying. So, Mr. Saylor, if you know, tell us. If you don't know, tell us you don't know.
Yes, I don't know.
and in that content department, you reported to Mr. Machuca, correct?
Tenure, yes. There was about 2 years in the beginning of my employment there that I did not. And then for about 6 years, yes, he was my direct report, or I was his direct report. And then when I asked for a demotion, then I reported to Christian Piles.
Do you know of any other content provider who got a $10,000 signing bonus at Rockfin?
No.
I think you already said you didn't know of any that got health care.
Not that I don't know anybody's health insurance situation.
One of the conditions of going to work for Rockfin was that you had to sign a PIIA, correct?
Yes.
And that was also signed by Mr. Floriani.
I'm sorry, at Rockfin?
At Rockfin,
Flow Sports.
at Rockfin.
Was it a PIIA? Did you have a copy of that? I mean, is there an exhibit?
If you go to Exhibit 166, do you have that, the offer letter?
Yes.
And if you go to the second page, doesn't it say that you are required to sign a proprietary information and inventions agreement without modification?
Yes, I see that. Although I'm frankly not sure if that's still in effect because I'm no longer an employee there.
You also agreed not to disparage Rockfin. Do you recall that?
I believe that was part of the agreement, yes?
And you agreed to confidentiality as well.
Yeah.
Correct? So you can disparage Flow Sports, but not Rockfin?
I can. But I don't, I mean, is that a rhetorical question?
I mean, wasn't the whole point to leave so that you could have freedom of speech and say anything you wanted to, and then you signed a non-disparagement agreement as soon as you got there?
Yeah, I mean.
Okay. Let's go to, is this F562? Yeah. Okay, let's go to F562.
I mean, there's a wholesale difference between freedom of speech as a human being and a journalist and speaking your mind about your former employer.
I'm going to ask that
the non-responsive portion be
Well,
struck.
there's no question to you at the moment, Mr. Saylor. Ms. Burgess is asking you about another exhibit, I believe. Did you say 562?
Yes, and it's also marked AO. It's another part of the offer. It's a follow-up offer letter. So I'm gonna give you the numbers without pulling those up. 562 and 664.
Is there any objection to 562, plaintiff's exhibit 562 or plaintiff's exhibit 664?
Not their admission, Your Honor, just their displaying.
All right, so plaintiff's exhibit 562 and 664 are admitted, but don't display them.
Okay, great. Do you have these in front of you though, Mr. Saylor or Ms. Klingsteisen? Can you send them to him?
I did.
Okay, great. Can you see exhibit 562, Mr. Saylor?
Not quite yet. Didn't come through yet, Ms. Burgess.
Did you say 562 or 552?
562.
562, okay.
Sorry, it still hasn't come through yet.
Do you have 664 handy? Let's see. Taylor, any luck?
Still hasn't come through yet. I'm sorry.
Yeah.
No.
Maybe you could tell him what document it is and he might remember it and doesn't need to see it. So,
Do you recall that? So you just saw a text a little while ago where where Martin Floriani told you on the 27th that he was sending you an offer letter, and on the second Saturday morning that he was sending you some paperwork, right?
Yes.
Okay. And what I'm looking at, and hopefully you'll be able to look at in just a moment, is exhibit 562 from Saturday, November 2nd, 2019 at 2:25 a.m. Okay.
Was that the evening that I quit?
It's the morning before you quit.
Yeah.
Okay. So do you recall that you quit on a Saturday night?
I wasn't sure. My recollection, I wasn't sure if it was a Friday night or Saturday night.
Okay. And and that same morning was the day that you got the paperwork from Martin Floriani, correct?
62. Yeah,
What time of day did you tweet out about Ohio?
it was in the evening at some point because I was actually watching Ohio State wrestle, and they didn't look sharp, and I tweeted something to the effect of what's going on in Columbus. And
Just getting timeline out. On the 23rd, you told Mr. Floriani that you would get NHSCA and other big ones. Let's go, right?
Mhm.
And then that's October 23rd. And then October 27th, he sent you a written offer letter to go to
Mhm.
work for Rockfin as a W-2 employee, correct? Is that a yes? I'm sorry.
Yes, I believe so. Yes.
Okay. And then on the 27th, on the second or the first, he came to visit you
Mhm.
in Pennsylvania. And wee hours of the next morning, that night or wee hours the next morning, he sent you paperwork, right?
It appears so.
And then later that day, you sent out a tweet and got in a tussle with Mr. Piles and ended up quitting, right?
Yes.
And we know that the next day on Sunday, November 3rd, you told Nick Velikat that you were glad to be on the team at Rockfin, right?
Yeah.
Let's, to get it into the record, let's go to 897. And this is listed as confidential, but we showed it, the page that I'm going to look at, it was already shown in the opening statement, page 1 of the PDF. Oh, they agreed to it. So that's 897.
Is there any agreement to 897? I mean, any objection, sorry?
No
No.
objection.
No objection.
897, plaintiff's 897 is admitted.
Okay, and so Mr. Weisrod, I think you can show this. Okay, this is when Mr. Floriani came to Pennsylvania the day before you quit to talk to you about the offer letter he'd sent.
I apologize. What was the question? I was looking at the text.
Sure, this is a picture taken when Mr. Floriani came to Pennsylvania the day before you quit to entice you to come over to Rockfin.
I mean, you want to color it, you're coloring it a little bit, entice me to come to Rockfin, but he came to discuss, yes.
Okay, and he'd already sent you a written offer letter, correct?
I thought you said he sent that written offer letter on the 2nd. That's what the previous document.
I'm sorry, have you seen 560 is 562 is the written offer letter? What's attached to the document on the 2nd is a different document. It's a model.
Exhibit 562 is an email with the offer letter dated Saturday, November 2nd. So that would be the morning after this picture was taken.
No, I'm sorry, you've got it wrong. If you look at,
Ms. Burgess, you've got it wrong as a statement. It is not evidence. It's a sidebar comment. It's confusing. It muddies up our record. Please stop making sidebar comments and please stop testifying. Just ask him a question.
Mr. Saylor, can you look at exhibit 560, the offer letter itself?
560, the offer letter itself.
166. Sorry about that. Can you look at 166?
66. I'm seeing several documents of the same body, of the same content with different dates. Perhaps that's the problem. 166 has an offer letter with a date October 27th.
That's right. And that was attached to exhibit 562.
Yes, but in exhibit 562, that is an email that's dated November 2nd. So what you're saying is Martin wrote an offer letter on October 27th, but sent it to me in an email on November 2nd, right? That's what,
No, I'm sorry, turn to 560.
60, 560. Sunday, that's what I'm getting, that's what I'm saying. Right? 560 has an email
Okay,
date
so
of Sunday, October 27th. And 5 there's another one that has the same
what is the second email?
email with a Saturday date.
Okay, so let's look at 560. It's called Rockfin Offer, and it's Sunday, October 27th. Do you see that?
Yes. Can I clarify? I have an email from Martin Floriani sent to me Saturday, November 2nd.
Right.
Is
And if you,
exhibit
that's
562.
right. Okay, if you look at 562, do you see that it is going forward from an email on October 27th, 2019 at 5:10 p.m.?
Oh, okay. Yes, I do.
Okay, I think that's the confusion. This is why it's hard not to have the document up in front of both of us. But if you see under that, you can see that that is where he wrote you what is 560 and attached the written offer, correct?
Yes. So the original email was sent Sunday, October 27th.
You tell us. She's not
That's right.
testifying. I think we've covered that. She doesn't testify. You testify. You can testify in a couple of ways. You can agree with what she's asking you. You can say yes or no or some other appropriate responsive answer, or you can say totally acceptable. I don't know, but she doesn't get to testify. You do. So what is your question, Ms. Burgess? And then we'll get an answer from Mr. Saylor, but he doesn't get to ask questions and you don't get to testify. I feel like I'm saying the same thing over and over. So let me stop and let you ask another question. But
So
please, I've said 100 times today.
at 562, and it's a second email on the string. Do you see that? Second email at the top that says attached is the model we were working with yesterday. See that?
I do see that.
Do you recall that, and this goes to 664, is that AEO as well? This goes to 664, have we already entered it? I think we've already entered that. That goes to 664, which is an Excel spreadsheet, but it's marked AEO. Do you recall that on the 2nd, late at night, Mr. Floriani sent you a spreadsheet modeling out what he thought you could make at Rockfin?
He sent it to me. I don't recall him sending it to me, although maybe he did. I don't know.
And when we look at 562, I actually
I don't have it.
when we look at,
Oh.
if we look at 562, it's the wee hours of the morning of Saturday, November 2nd, that same, where you quit the same day. And he says attached is the model we were working with yesterday, correct?
Okay, yeah, yeah.
Okay. And I'm not going to put it up. It's already in evidence though, but that model was a prediction of how much you could make on Rockfin, correct?
Well, it wasn't a prediction. It had inputs and outputs. It was.
And you guys were working with that together when he was in Pennsylvania, correct?
Working with that, he showed it to me.
Okay. They aren't. Oh, I need to admit 562 and 664 if they are not admitted.
No objection, Your Honor.
562 and 664 have already been admitted.
Thank you. Let's go to 302.
302.
Well, it looks like you're going now to a different exhibit.
This is just a one quickie question, Judge. If you
What's the
we can get
number?
through 302.
All right.
302. And I was going to ask right after this what our timing was, but if we could just get through this one, that would be great.
Okay. What's your question
Okay.
about plaintiff's exhibit 302?
Can that be displayed?
Is there any objection to
Mr. Weiss?
302?
No objection.
No objection.
302 is admitted.
Okay, who is Mr. Bashada?
He is the gentleman that was, I don't know his title. He either owned or operated or he had a brand called Scrap Life. He was involved in a brand that's called Scrap Life. And he was a personal friend of mine.
Okay, and these are your texts with him?
I see like 42 texts.
Okay, and this is just the first page. Mr. Weisrod, can you go forward? I'm sorry? What is the line?
Your Honor, I guess I want to clarify, is the suggestion that this is only with Mr. Bashada or all of Mr. Saylor's communications that they obtained at this time?
I have no idea. So, Ms.
I guess
Burke,
I,
wanted to ask a question, but I understood you not to have any objection to this exhibit. So let's see what her question is.
Mr. Weisrod, could you go to line 3180?
I'm not entirely comfortable with all my text messages being shown to the public. I don't know if that matters, but
We're
Well,
just gonna focus on this one. Do you know what page it is, or it's in a spreadsheet? Uh-huh. Sorry to put pressure on you, Mr. Weisrod. While he's doing that, Mr. Saylor, is Mr. Bashada the same one that sent you the licensing agreement about the Scrap Life t-shirt?
yeah, yes.
Here we go. Okay, and this is, so Mr. Weisrod, could you pop that out? This is November 5th, 2020, November 5th, 2019. And you told Mr. Bashada that you were intimidated. Was it intimidated or intimated that was going with Rockfin because it might be against the non-compete, correct?
I said that your HR staff sort of intimated that going with Rockfin might be against non-compete.
And that was in your exit interview?
Yes, ma'am.
And you replied as well that if they fight, I'll put them on blast publicly. Do you recall that?
Yes, ma'am.
And he replied with a lot as well. But you said if they fight it, I'll put Flow Sports on blast publicly, correct?
Objection asked and answered.
Sustained.
The fact is that that's what you did, right? When you got sued, you released information about Flow Sports and then you threatened to disclose more.
I may have tweeted some things that I didn't like Flow Sports and I didn't like what was going on and that it was unjust. This lawsuit was unjust. I don't think I gave any specifics or anything like that.
Your Honor, does the document need to continue to be displayed for any reason?
No, in fact, it can
Don't
come down.
know.
Mr. Saylor, that one of the tweets that you gave was a tweet giving the relative earnings between people in the wrestling department, correct?
Yes, I'd like to, I'm glad that got brought up because, Mr. Machuca testified that as,
Back to non-responsive.
Sustained. Wait a minute, hang on. Ms. Burgess, ask him your question.
Right. My question was, one of the tweets that you sent out talked about the relative earnings of various people in Flow Wrestling.
various people, two people. One was Ben Askren, the other was Wrestling Nomad. Ben Askren had just come on as a contractor, and Ben told me.
I'm gonna object to the hearing.
Don't tell us what he told you. The question was just whether or not you tweeted out that information. That's all.
Very generally.
Okay.
No, there's no figures in there.
I'm gonna say this is a good spot to stop, Judge.
Okay. We will be in recess until tomorrow morning at 10 a.m. But before we break, let me just remind you of a couple things. One is I asked, please, to have a plaintiff's exhibit list in a little bit larger font than what I have. It's really hard to read. Could you just get somebody to enlarge the font and resend that to everybody, please? It's just.
I think that Mr. Boucheron sent that yesterday, but it just may
I
not have.
have not received that one yet. So if you could just double check to make sure it's been sent, that's great. The other thing I asked about had to do with a list of agreed exhibits that could be pre-admitted, so we don't have to take a lot of time on ones that nobody has any objection to. When you send the exhibit list, if you haven't already, that would be a good time to also mark on there the ones that you've agreed to, or send me a separate document that has a list of all the agreed ones. Either way, but I feel like we waste a lot of time going through things that nobody has an objection to. If you have an objection to it being displayed, but it's otherwise admissible, I'm fine with that. Just communicate that to me and to the court reporters, and we will be most appreciative. I'll see you in the morning at 10 a.m. We'll be in recess until then.
Thanks, so.
Thank you, Your Honor.
Hey, Brent,
Oh, hi, Martha. I'm just getting off. I'm still on your.
that's fine. Brent, are you keeping track of time?
No.
Okay. Is there somebody keeping track of time?
You need to speak to the judge about it.